Folks, this is not a good day for Canada. Just recently, the court case representing 330 of Canadian Armed Forces' finest was thrown out of court. This court case, if you're not following, was representing these 330 members that were clearly abused during the COVID era. Torture, humiliation, medical misinformation, inability to follow protocol were all part of this whole big mess. This didn't have to happen. All we had to do was just follow the rules that we already had in place. But our military decided that this was not sufficient, and they acted like dictators. From low-level managers to the highest-ranking generals, they all took part in a massive abuse of power. This court case has now been thrown out and effectively sent back to the Canadian Armed Forces grievance process, which is clearly broken. I chat with Catherine Christensen in this episode, a regular here on the podcast who has been updating us about what is going on with this case. And the troubling thing is, the judge that presided over this case has now presided over 2 court cases regarding mandates, and both have been thrown out. And surprise, surprise, yes, this judge was appointed by Justin Trudeau. Stay tuned for more, and make sure to go to the very end of the episode, because I chat with Catherine about our Constitution. And if you're a Canadian, you're going to want to learn about this right away, because it troubles me still to this day, and I don't know what to do about it. So stay tuned, make sure to like and subscribe, and see you on the other side. I'd like to thank today's sponsor, Natesto. Natesto is an FDA-approved testosterone replacement therapy. For those of you that are suffering from low testosterone and want to know more, head to natesto.com for more information. Let me fill you in, folks. I've written a new book. It's called Harden the Up. Yes, that's the actual title of the book. The book is 19 chapters of the best actionable intel on how to get yourself fit, healthy, and moving in the right direction to make yourself harder to kill. If you want to get yourself a copy, you're going to have to join the pre-sale list. Like, I literally don't have a book in my hands. This is how early you are. I get it. You might be on the fence. Why should I buy another book written by a veteran? Well, I'll tell you why. You want to be cool, right? Well, you're going to want to be like all the cool kids that are saying some really cool things about this book, like Dallas Alexander. He's pretty cool. General Thompson, former task force commander at Kandahar. Tony Chapman, Dr. Elliot Justin. Who else? Oh, Tim Jensen of Grunt Style. Not only did he think the book was cool, he thought it was so cool, he wrote the freaking foreword to the book. Go get your copy as soon as it comes out. You're going to get an email, and you're going to get access to the Harden Up book page right away so that you can start hardening up. If you want more information, you're going to want to join the pre-sale list. Do it right away. Join the list. Join the list. And you can be one of the very few that gets their hands on one of the best books of 2024. Ebook and audiobook drop on the 28th of November. On the 29th, you can get your paperback copy at Amazon. Link will be sent to you in your email. Be one of the first to get your hands on a copy of this amazing book and become harder to kill. Peace. Folks, Catherine's back on the show. One of our regular guests here, and we've got big news in terms of the lawsuit that Catherine was bringing against the Canadian Armed Forces for abuse of power for 330 members that she's representing. It's been thrown out. Now, we're going to discuss that. We're going to get a little bit into the weeds on that and hear Catherine's point of view. And in my opinion, we're heading on like a one-way train to a constitutional crisis. But Catherine's going to clear that up for us and maybe put my fears to rest or not. But Catherine, it's always a pleasure to have you on the show. And let's start right away with give us a lay of the land. What just happened? And we'll start right there.
Well, hi, good to be back, Dave. I wish it was just different news. So we went into court in September on a motion to dismiss from the Crown to dismiss our lawsuit. The Crown was successful based on a couple of points. The biggest one was that the justice said that the grievance system in the Canadian Armed Forces should have been used, can be used, and is the be-all and end-all for anything that happens in the Canadian Armed Forces. I have some opinions about that we can get into.
Yes.
And the second part of it was she basically said that our statement of claim didn't clarify enough for her to say that we had any right to bring our 38 claims, including charter claims, which was interesting because, as you know, the Military External Review Committee clearly identified charter breaches with the COVID directive. So that is what the Justice's decision was, and that's where it sits right now. Now, I met with my clients last night and went over some of the options, and right now they're deciding which option they would like. When I first saw the judgment, I'll be honest with you, I looked at that and thought, there's no grounds for appeal here, because many people misunderstand that an appeal is not an automatic thing. You don't get an automatic appeal if you don't like a judgment. There has to be an error in fact, or an error in law, or a combination of the two by the justice who heard the original hearing. And also, you have to apply to the Court of Appeal to ask them to hear your hearing. So, is there a possibility we might appeal? We've found some errors in fact, we found some errors in law, and we will see if my clients want to buckle in and strap on the kid again, and away we go for another hearing. We will see what they decide, because that's not my decision to make. I'm happy to represent them either way. But I got to tell you, I have some very upset Canadian veterans.
I was just going to ask. I was just going to ask, what's the general sentiment with the folks that are being represented by you in terms of, like, are they furious? Are they disappointed? Where does that stand right now?
The majority are furious. They are getting a first-hand account of how our legal system does not exactly represent ordinary people. They are very disappointed that they put on a uniform to defend Canada that they're discovering does not work the way they thought it did. And certainly our courts need reform. Keith Wilson, back when the trucker convoy was going on, I watched him do an interview with Viva Fry, and he said that one of the things that will be revealed is how broken our justice system is through all of this. And given that no one's really been successful on anything that even mentions the word COVID in Canadian courts, is a big sign. Right.
So the big elephant in the room is essentially what you just mentioned earlier. The judge has said, nope, this is a Canadian Armed Forces issue. Let the Canadian Armed Forces deal with it through their grievance process. Now, let's dig into that a little bit. What does that essentially mean for the folks that are part of this lawsuit? Because some of them are still in the forces, but a lot of them aren't.
Right.
So for folks that are not up to speed, and I'm thinking about my parents right now, because literally before coming here, I dropped off my kids. They have a pet day today, so they're staying with grandma and grandpa. My mom asked the question, hey, what's going on with the lawsuit? I'm surprised. How did it get thrown out so fast? So I gave them kind of the lay of the land. But for those individuals that are not military, that don't know how the grievance process works, what does this all mean that now the decision has now been placed back in the Canadian Armed Forces' hands? Fellas, bring it in. Nice and tight. Bring it in. Nice and tight. We need to talk about it. All right, seriously. We need to talk about something that most of us don't want to talk about. That's why I put on my nice blue dress shirt to bring a bit of seriousness to an often hilarious topic. But your sexual health is no joke. Seriously, though, sexual health needs a lot more attention than it's been given. Let me go over a few things here. Research has shown that regular sex, 1 to 2 times per week, can reduce the risk of cardiovascular mortality by 50%. Bring that one to your wife right now. lower the risk of prostate cancer by 33%, and reinvigorate your mind and body. The problem is 40% of men in their 40s, 50% of men in their 50s, and 60% of men in their 60s experience some form of erectile dysfunction. This is even worse in the veteran community. On top of all this, erectile dysfunction is correlated with a future cardiovascular event and is an early warning sign of a future issue. This is why Dr. Elliott, board certified urologist and friend of the podcast, has created this one of a kind, first in its category, revolutionary device called the Firm Tech Ring. This high-speed tech for your dick will give you real-time data and allow you to see how many nocturnal erections you get every night, which can be a great bit of data that you can bring to your doctor for a future conversation. Not only that, this data could literally save your life. You know, I'm all about improving the health and lives of the veteran community, and that's why I've paired up with Dr. Elliott Justin to provide you with a 10% discount if you head to the link that's here in the description to get yourself your first Firm Tech Ring if you use the code DMorrow at checkout. So head to the link in the description and start tracking so that you can start banging. All right, brother. So go do what you got to do and be one of the first to bring a whole new meaning to being hard to kill. I want to be able to save you almost $4,000 per year. If you haven't got yourself a copy of the Nimble Warrior, this is my first book, and it is all based on what I've done in order to get myself out of the pain cave. Let me explain. Over 60% of Canadian Armed Forces veterans are experiencing chronic pain. Of all the medical releases, about 42% are musculoskeletal injuries. If we boil that down, a lot of us are suffering from back, knee, and hip injuries. What that means is we're experiencing high levels of pain, which reduce your quality of life. If you want to change that, I recommend getting a copy of my book, The Nimble Warrior, right here. You're going to be able to find a copy on Amazon, and you're going to be able to start doing the protocol that I use to help myself get out of the pain cave when I hurt my back. So head over to Amazon right now. Description is in the bio. Link is in the bio, and you're going to be able to get your own copy in time for the Christmas season so that you can start moving and grooving and feeling a lot better about yourself. So head to the link, head to the description, and get yourself a copy of The Nimble Warrior. Peace.
Right. So how the grievance system works is if a member of the forces feels that something has happened that they don't feel was right or was done wrong, they can file what's called a grievance. That grievance goes to what's called an initiating authority, which by regulation should not be the person that they're complaining about. Like if they're complaining about their commanding officer or their sergeant major, it doesn't go to them as the initiating authority. It goes to another commanding officer outside of that particular regiment or battalion.
Right.
So it goes to an initiating authority. The initiating authority reviews what's been submitted and decides if it's a valid grievance or not. If it's a valid grievance, then they decide if what's been asked for restitution for the grievance is valid. And then if it's not, they say, nope, there's nothing here to grieve. The person then has the option to escalate to have it reviewed by the final authority. The final authority in the Canadian Armed Forces is the Chief of Defence Staff. When it goes to the final authority, it then gets sent off to the Military Grievance External Review Committee, which was implemented because they were having problems with the grievance system being corrupted and not being fair. So one of the solutions was to get this external review committee, which is staffed by lawyers, etc. And they review the grievance and they decide if, in their opinion, the person's been aggrieved or not. They then give their opinion to the Chief of Defence Staff, who still holds the final power, the final say of whether there's been a grievance or not. The CDS does not have to agree with the committee. Here's where it gets really interesting. When it gets to the final authority, the Chief of Defence Staff has no time limit to give an answer.
Oh, wow.
So I've seen grievances take 4 or 5 years before we get a decision from the Chief of Defence Staff. I've got some that are sitting there final authority, not just this case, that has gone through 3 chiefs of defense staff. They're on their 4th one now, with no decision made. Rory Fowler, who is a previous JAG officer, he has publicly stated that he's still waiting for a final authority decision on a grievance of his when he was serving 18 years ago.
Oh.
So anyway, if you can get a decision from the final authority, you then get 60 days to decide if you would like it to be have a judicial review of that decision. And then it can take 1 to 2 years before it's heard in the federal court for a judicial review, which is sort of the equivalent of an appeal. And the member has to pay, they can either represent themselves in federal court or they have to pay a lawyer to go into federal court to challenge the CDS's decision.
Okay.
So, and that's a significant amount of money to pay.
Especially if you're a private or a corporal.
Yeah, exactly. Yeah. When I get a call from a master corporal or a sergeant who's definitely has grounds to go into the federal court, and I say to them, well, it's going to cost $10,000 to do a judicial review. There's an access to justice problem there. Mm-hmm. But tell me that the grievance system works really well. And in the case of this mass tort, here's the real kicker. What they were disputing and saying was an abuse of power was an order of the chief of defense staff.
Right.
Who then becomes the final authority to decide if the order was legal or not. And the court last week said, that's okay, that's fine, that's working.
That's a kangaroo court.
That's a kangaroo court.
Realistically, that's
really,
what that is.
Yeah. The idea that the grievance system is the be-all and end-all. And ironically, this same justice heard the postal workers' COVID lawsuit, and the judgment, reasons, costs award, almost identical, word for word.
Okay. I want to get back to the justice. But before that, in terms of damages from a grievance, I think I remember you saying that there is no possibility of damages being awarded in a grievance. It just allows you to make right the wrong during your service. So it could be, I don't know, it could be anything, right? It could be sexual misconduct. It could be abuse of power. But if I understand correctly, you can't get a financial reward or damages from that process, right?
Nope. And you're probably not going to get it in a judicial review either. So then what's the point of
then what does the grievance actually do then? Just to say, actually, hey, troop, you're right. We're sorry. Is that essentially it?
That's pretty much it for every grievance. Yeah. And
that doesn't hold water then.
You have a very limited time to bring a grievance from when something happened. And it has to be an act of your chain of command, an act by somebody that you feel you were aggrieved. And you have a very limited time period to get your paperwork in and get the process started. And again, with this mass tort, here's where we run into issues, because some people were released so fast, 2 weeks to a month. They were trying to find housing. They were trying to find a job. Filling out a grievance was the last thing they wanted. Some people when they got their release date, went to file the grievance, and they were told, oh, no, we actually technically released you a few months ago. You can't file this grievance because you've been released. And they're like, no, I haven't. I'm still here. And they're like, no, technically. And that, I'll be honest with you, that decision we did grieve separately, went to the final authority, and the court agreed with the chief of defense staff that no, nothing bad happened. That was okay to backdate the grievance. That's fine. No problem.
This is so corrupt, Catherine.
And then if you're out, you can't grieve. So if something bad has happened to you and you are out, they've pushed you out the door real fast, there's nothing you can do about it. You can't grieve.
Okay, this brings up another point. I was just having this chat with a friend of mine here like an hour ago. How can a grievance be still at let's say on the desk of the CDS and you be released? Mm-hmm. Isn't it impossible then? Because you're no longer part of that bureaucracy. You're out of the military. So then what incentive does the military have to resolve the grievance if you're out? Because what recourse do you have? You don't wear a uniform anymore. You're not in the system.
And here's the other thing. The CDS does not have the authority to reinstate you into the forces. So if
Who
you
does?
were objecting to a 5F release and the CDS agrees with you that you should not have been released, he or she does not have the power to put you back in.
Who does?
Nobody.
Wait, nobody can reinstate you?
Nope. You're done.
Not even King Charles?
Nope.
Could he do it?
What you can do if it's this is specific to a 5F, is that you can reapply and the CDS could approve your application. But there's no guarantee you're going to come back in with your rank, with your you're not going to get benefits, back pay.
Wow. Okay, so parallel.
This is our great grievance system that they want us to use.
So the parallel in the United States, President Trump has said, I will reinstate everybody that was released under the COVID mandate era. Full pay, back pay, everything. Yeah. But he has that authority because he's commander in chief.
Yes.
So he can just sign an executive order and be like, all these guys are back in.
Here it would require legislative change.
Whoa. Okay. I thought
and the will to change it is the other part of it.
Right. Oh, I thought it would take, if there's a government change for them to say, you know what, all these guys and gals are kicked out, they're back in, CDS make it happen. But they can't.
No, they don't take orders from the Prime Minister.
Well, I mean, I think precedent has already been set based on our conversations that clearly the CDS does take orders from the Prime Minister.
Yes, that's. I mean, that has happened, legally or not. So. I mean, to compare to the U.S. as well, is that it's been announced that the new Secretary of Defense intends to recall a lot of generals and colonels and court-martial them.
Really?
And in the U.S., they can do that. In Canada, they only have a year after they leave to bring them back.
That would be amazing.
Mm-hmm.
Hegseth is going to scorch earth. I just started listening to his podcast.
I would like to be at the table when he meets our Chief of Defense Staff the first time.
Oh my God. Okay. All right. Okay. Can of worms open. Can of worms open. All right.
But it would be nice. See, the thing with Canada is that in order to lead a department, you have to be elected as an MP first, member of Parliament first.
Right.
And in the States, that's not how it works. They get appointed by the president, and away they go. So that allows President Trump to not only pick and choose, but pick people he thinks are the best to achieve what he wants to achieve in those departments. So
not based off a limited pool here, because you're really only picking from 230? Was it what's a majority? Something like that, or 138 or something like that to have a majority. So, yeah, that is true. Actually, now that you point that out, yeah, it's true. They do just appoint. Like Hegseth hasn't won anything, but he's going to be the Secretary of Defense, not because he's not a senator or congressman. He's just going to get appointed. Which, yeah, same with RFK. That makes a lot of sense. You see it every day, but you don't put two and two together. That here we can't do that. Okay, that brings up a whole.
You talk about constitutional reform. There's something that could be changed.
Again, yeah, that's another question I want to ask. But before that, I want to go back to Justice Coughlin, who was the judge presiding over your case. You mentioned she also presided over the postal workers case, where their rights are obviously infringed upon. They were fired for not following the mandate, but I'm not tracking the decision on that. The lawsuit was based on wrongful dismissal, but she threw it out, or did she send it back to the other governing body? I don't know what happened there.
Yeah, she dismissed it. The lawyer Leighton Gray, who brought that lawsuit, compared the two judgments, and he was the one that pointed out that they're pretty close together. Because, of course, the postal workers are unionized, and they have a grievance system.
Right.
So she said, they should have used a grievance system. It's fine. That's what it's there for. I have a little bit of a problem with that, because the grievance system in a union is very different than the Canadian Armed Forces. With the Canadian Armed Forces, we're talking a different kettle of fish. And of course, the other thing that Justice Conkling did not disclose was that she, before being named to the bench, was a lawyer for the Department of Justice and represented the Minister of National Defence and the government in several lawsuits against the Canadian Armed Forces by troops. Can I do anything with that information now? No. But you have to wonder, is there a conflict of interest, or is this part of the flaws of our system? We have appointed justices, and a faithful public servant got appointed to the bench. Is it the first time it's happened? No.
Right. Well, that's interesting. The issue that I guess is bothering me is that these troops, they don't have access to justice or the justice system. That's really troubling to me because they're Canadian citizens. They clearly cannot access. The reason why this lawsuit exists is because the grievance system is, as you said, it's broken. You cannot get justice through this system. You cannot claim damages, where a lot of these individuals, they lost their careers, or the ones that are still in, I imagine their careers are severely busted up because of this. Their chances of going up the ranks are probably pretty low. So therefore there's a financial damage there. And not only that, but morally, ethically, like everything that you could possibly break was broken during those 2-3 years. But how can you have a system that it's supposed to represent all Canadians? And I talk about like a justice system, the Charter of Rights. But you clearly have an example here where if you are a member of the Canadian Armed Forces, you do not have access to justice like every other Canadian. I don't know what this means, but the only thing I can think of, like this leads to a constitutional crisis, because if you can't access justice by the sheer virtue of you being a forces member, that's a big freaking deal. Or maybe I'm just blowing this out of proportion.
Nope, I would absolutely agree with you. That's basically what it's come down to, is that it's okay for the chain of command to physically torture troops. It's okay for men in uniform to hunt down pregnant women that are members of the forces. It's okay to lock a young woman in a room with several male senior officers and force her to do something. It's okay to accuse innocent people of serious crimes. It's okay to deny protection and justice to military families that are suffering from domestic violence on military bases. It's okay to say, you know what, you don't get any religious support either. The chaplains can't offer prayers. You have no religious protections at all in the Canadian Armed Forces. It's okay if senior command does something unlawful or has an unlawful order, the courts say, hey, that's okay. Why would they need to follow Canadian law? You should grieve it to the person that brought it in. It's a real tragedy, I think, to say to the people that put on the uniform to defend our country that you don't have. When people first came to me 3 years ago and their RSMs and their COs were telling them you have no rights in you have no rights at all, and I was like, no. They never gave away their rights when they signed on. When you put that uniform on, you're still a Canadian citizen. If you get arrested for a crime in uniform, you still have all your rights that a criminal court allows. And yet, here we go. I get a justice that says their rights don't really matter. Now ask me, who wants to sign up and be a member of the Canadian Forces if you have no rights?
Right?
Mm-hmm.
Right?
Yeah. Do you want to talk about a recruiting problem?
If you strip away any one of your rights, you're stripping away your rights. And so if you're missing one of the fundamental underpinnings of our rule of law based society, which is being able to access timely justice in the justice system, that's a really, really big one. Mm-hmm. And when you get into trouble, what do you do?
So is having a military that thinks they're above the law.
Well, yeah, that's a meta problem.
That just got reinforced, that they can do whatever they want.
Yeah, because there's zero consequence. Mm-hmm. If you can't access the justice system, because clearly the military justice system is non-existent, 18 years for a grievance. That's insane. I mean, and then you can just arbitrarily backdate when you release somebody. Like that's dictatorial stuff. And I see it in comments, like I'm on the National Post article about the lawsuit. And like the first comment here, as a former member of the CF, this is from Gary Estabrooks. I fully agree with this judgment. The number of CF personnel refusing after being ordered, which is not correct, to take this vaccine, as this was against their charter rights, et cetera, was an offense under the NDA, in my opinion. He's 100% wrong.
Oh yeah, on a few points there.
But yeah. like the military is not a democratic organization; it's basically a dictatorship, a very benevolent one.
Yeah. Now keep in mind.
Imagine this is maybe this was I don't know. You have no. If this is what the belief system is in the forces, that we are a dictatorship.
Yeah.
Oh my God. Like, how did we miss that civic lesson? No, it's not a dictatorship.
No.
It's not recruits that come like off the street as conscripts. We have a professional military that follows Canadian law, which is a democratic based system. How is it that somebody can make a comment like this so confidently without any realization that this is not how our system works, but clearly this is how it's believed to work? I don't know where to go from
Keep in mind here, not a single person, not one person was ever charged with not following a lawful order.
Right, because it wasn't an order.
We got someone in the comments saying, oh, well, they should be charged as far as we're concerned. Aha. Why didn't they charge them? Because then it would have gone to court-martial, and then they would have had to defend their decision. Why did they not make it actually an order under NDA 126? It gave the authority to order a vaccination. AIR didn't do it. Why? Because then it could be challenged in a court.
With a real lawyer.
With a real lawyer. So, the senior command made a conscious choice to make it an administrative action so that they could try and hide their wrongdoing. And part of what they were counting on was also the fact that you can't criticize the armed forces or the government while you're in uniform. So they figured it out, everybody gagged. And that was when they came to me. That's one of the functions that I saw as important, was they couldn't touch me. I can talk about it all I want, and they can't touch me because I'm not in the chain of command. So that was like, okay. Was it my intention to become, a vocal advocate? That wasn't on my career path, but it is now, because somebody has to speak up for this. And you know what, Dave, you know this because you're a veteran. You box Canadian troops in a corner, they regroup and they come back out.
Yeah,
these people are not done.
No.
Not by a long shot.
With a fierce vengeance coursing through your veins.
Yeah.
Medusa, bats.
It took the third try to actually accomplish that one. Vimy Ridge, how many months, years did they slam themselves against that battlefield until they won? That's the actual ethos of the Canadian forces that I know. And that's what I'm seeing in my clients. They're not giving up.
Well, yeah, I mean, unfortunately, we have to turn our aggression and our fighting ability against the very government that we we can't say we swore to protect it, because we swore to the monarch. But get my point. The idea that we're now in a battle against our own government at an epic scale is really troubling to me. But I think it's a necessary part of our growth process, because I don't see how we get out of this without a new constitution. I'll be honest, all these conversations I've had with you, when I mention it to people like my parents, they're like, oh, I had no idea. Of course you don't have any idea. We don't teach civics in any of our schools. I only learned about the charter 2 years ago from you. I didn't know what it represented. I didn't even realize that Canadian Armed Forces members have every right on that charter. There's no separation, and correct me if I'm wrong, from the laws that govern all Canadians and the laws that govern military members. Now, from what I understand, If you're an American, you have the USMJ. That is a different system than
Mhm.
their normal set of laws for civies. So they can't do the same things that we do here. And that seems like a big whoopsie in terms of creating the laws here and the law of the land in Canada, that you kind of left the door open for troops to be like, hey, this is wrong. I'm bringing like actual legal counsel. Like, you can't confine me to barracks. You can't charge me for this. You can't have me do all the other like nonsense things that the military forces you to do, because they're like, you're ours. We're a dictatorship. We can tell you to do whatever we want. It's like, actually, hold on a sec. I know my rights, and I know that the law applies to me just like every other Canadian citizen, but you've been holding it back from me and pretending like it doesn't. And now we've been learning. We're like AI now. We're like a collective. We're starting to listen to podcasts. We're listening to people like you. We're starting to understand, like, actually, this is not the system that you've been telling us it is. And we're going to start using the system to fight back. And the only way I can see this resolving itself is there has to be somebody at some point that says, hey, we need to separate ourselves from our old antiquated system that requires the monarch to kind of regulate everything, which actually doesn't, because what is King Charles going to do for us? Nothing.
Mhm.
So we
Right.
repatriate everything and we have our own Independence Day. And I don't see that being a violent thing. Jamaica just did it. Like, a lot of countries do it. It doesn't end up in bloodshed. It just ends up in a new constitution. Now, maybe I'm way off in left field for most people, but that's how I see the next phase of Canada shaking out. And
Well,
I'm curious to know what you think.
and it doesn't even need to make faster changes. We don't even need to reopen the Constitution. I don't know if you were aware when the Princess of Wales was pregnant with her first child. The law was changed that the firstborn would become the next monarch, male or female. Because prior to that, is primogenitor. So the firstborn male, secondborn male, thirdborn male. That's why Princess Anne would have been fourth in line when they hadn't had children yet. So the law was changed to make it so that if Kate had a daughter first, that would be the next monarch. Okay? And that was changed in Britain. Canada never ratified that in Canada. So if there had been a girl first, would have been queen, but for Canada, it would have been the firstborn male as king, because we never got around to getting the law changed, and then she delivered a boy. So it just kind of left. So Canada could change the law to say that we don't recognize the King of Canada anymore.
Just like that.
Just we have that power in our parliament if we choose to exercise it.
And I don't think the British would come and send over a division to
fight
that off.
So.
I think they'd be all right with that.
They've got so many problems right now, and they don't have the manpower either.
I think they'd be all right.
Yeah. So, we're members of the Commonwealth because we still recognize that we have a monarch.
Okay.
That's part of it. So, it could change. I've always been a monarchist. I never had a problem with it.
Mm-hmm.
But then I don't think we've seen the reality on the ground of how that affects us when things go really sideways.
This seems like a thing.
Yeah, this whole thing over the past 5 years has really broken open how our system doesn't work, or a lot of our systems don't work. It's also the corruption side of things has really gotten exposed in a way that, this is the thing. As I'm talking to my clients, and they're talking about, like, we have hundreds of thousands of pages of evidence of wrongdoing in the Canadian Armed Forces, and if I put all of my cases together, we're looking at 1 million pages of bad behavior on behalf of the Canadian Armed Forces. But it would just end up being another Liberal scandal. That's how this is the other part of it. How do you make it so that the next government coming in is aware there's big problems and we have solutions? Because these are smart people. They're very capable people who have great ideas.
Mm-hmm.
They don't just want to complain. I mean, they're not in the smoke pit bitching and not doing anything. They actually have solutions.
Yeah.
And that's where I see some of the advocacy needs to be, here's how we fix this, and then getting the political will to implement the fix.
Yeah, I think that's one of the biggest things. And the political will typically only comes about from the people getting pissed off and demanding.
Well, our neighbors to the south just showed you what happens when the people take their power back.
100%. 100%.
That's the lesson down there. So you think you're powerless, but look what they did.
Yeah, exactly. I when we were having this conversation offline before we hit record, that for myself and pretty much all of my friends, we were never Trump supporters. It was very weird to all of a sudden be in the same position I was 8 years ago in terms of my principles, my morals, my political leanings. And now all of a sudden I'm like, well, I'm definitely not on that left side, like the liberal side, the Democratic side. I don't recognize any of that. That's not what I stand for. So I guess I'm with Team Red now, or in terms of Republican side. But that's really weird to me. But it seems like that polar shift has happened, and it seems like the left they're all in on totalitarianism, on tyranny, where you have judges that just arbitrarily rule. Like I'm just looking at the ruling here on the National Post, Catherine. Like the things that she mentioned here, you just mentioned evidence, and I'm just going to read directly from the article. So, ruling in favor of the government's motion to strike the case, Associate Judge Catherine Coughlin repeatedly discounted the plaintiff's claims under the Canadian Charter of Rights and Freedoms because their pleadings were devoid of material facts or evidence to support the allegations and prove a reasonable cause of action. You just said there's like millions of pages, hundreds of thousands of pages in this case alone. So how does a judge come to the conclusion that there's just no evidence? Is it just an opinion, not based on fact? What does that mean?
Here's the thing: in a motion to strike, we shouldn't have to prove what we've put in as statement in our statement of facts on our statement of claim. And you've seen our statement of claim. There's pages and pages and pages.
I have it right here. I have it open.
Of facts. In a motion to strike, the court has to make the assumption that all of that is true. So she's saying that all the statement of facts that show no evidence of any wrongdoing.
And she's saying that effectively, that literally every one of the 330, there is zero evidence in any of their claims. Yeah. And like I can just read, just based off, there's about 2 paragraphs for each individual. It's establishing that this is what happened, which was wrong. And isn't the point of the mass tort that each one of these has to be ruled on independently? So how can she just make a blanket ruling on 330 of them? I thought every one of them had to be ruled on, like, yeah, this one, no, this one, yes, this one, no, this one, yes. Or am I out in left field on that one?
Yeah, well, the other thing is that our brief for the hearing, this one hearing, was over 6,000 pages of evidence.
That's a beast.
So I was not expecting the ruling this quickly. I thought there's no way that a justice can review everything that we submitted in order to decide whether to accept it or reject it in 2 months.
2 months, yeah.
Maybe she's got a big team of people. I don't know how the federal court is organized, but I thought it would. I've done judicial reviews with just one client and not a whole lot of evidence, just strictly some paperwork, and I've gotten a decision. It's taken 6 to 8 months, sometimes a year, to get a decision. And this one was real fast.
I wonder if there had been zero mention of the word COVID or mandates in any of this. It'd be hard to make a claim for a lot of these folks. I wonder if that would have made it even harder for her to make a decision, because clearly, like, this was, it says here numerous times that there's, what she call vexatious Canadian Armed Forces vaccine mandate lawsuit lacks material facts, because wording was used that was in bad faith. But like I know that the way you're basing things is based on factual evidence that is literally available to everybody. So I'm just, how does a judge come to these conclusions? It's like she's in one world and the rest of the world is in like the real world.
Mm-hmm.
That's how I read this, because there's, experimental gene therapy, biologics, without any basis for these statements. It's like that statement, just those words alone was grounds for her to say, "Yep, nope, sorry. This is based on like conspiratorial nonsense. So therefore, this whole case is thrown out, even though there's clear case that these individuals had their rights stomped on and were clearly abused by the chain of command." So is that essentially what they based it on? Just some political
that's
ideology?
What they based it on. Yeah. The Crown during the hearing, the Crown lawyer said this is all conspiracy theory.
I missed that.
Yeah, no,
really? She said that?
No.
He said that.
He said that. Yeah.
Oh, okay.
Yeah, and she accepted it. She accepted it because she's put it in her ruling.
Wow. Okay, where do we get? Where can we find that?
As you know, the words that I used are now actually accepted words for what was going on. These are they weren't made up words. These are actually, scientists are now saying these words. Accepted scientists are now saying these words to describe what happened. So, yeah.
Well, I mean, it's going to be interesting to see the next 4 years in the United States, right? There's going to be a whole can of worms that's just going to be unleashed.
Oh, with Kennedy coming in as health secretary, there's about to get a whole bunch of stuff blown wide open.
Right. And, the very wise, smart, well-educated doctors and experts that have been screaming into the void for the last 4 years will now, I guess, finally have their day, because just because they have an opinion that's contrary to the mainstream doesn't mean that they're wrong. Actually, you should always listen to those that dissent, because like in the military, the dissenting voice may be the best one to listen to. And that's an important concept that I think we completely lost. The dissenter likely has a very strong reason why they're dissenting, because it's hard to go against the grain, because when you see all your friends, when you're worried about your career, it's easy to go with the flow. It's easy to say, yeah, well, you know what? Yeah, it's kind of bullshit, but just play the game, wink, wink. That's endemic in our culture. So the ones that are saying, no, we got to take pause for the following reasons. And I'm not crazy. I'm literally a doctor. I know what I'm talking about. Just those individuals are finally going to have their voices amplified with overwhelming evidence that things were clearly corrupt. And I don't know where we go from here, though.
As you know, Dave, I was a nurse for 20 plus years, a registered nurse. I saw doctors have conflicting opinions all the time,
which is great.
That's why you would go and get a second opinion.
Correct.
Because you wanted to hear, is there another diagnosis, another treatment option, whatever. And then with COVID, it was like, no, you're not allowed to have a different opinion.
I know.
They went after the law societies. I got to tell you, they've been a little more circumspect about going after lawyers that have been willing to stand up. They're being a little more careful, probably because they know they know what we know, that when we don't have freedom of speech in Canada. That's, I think, been a big wake up call for people. Because Section 2 of our Charter of Rights and Freedoms allows the government to take away our rights if it's justified. Now, if you're going to talk constitutional reform, that clause needs to go.
Okay, yeah, I'm glad you mentioned that. That was on my mind too. So, like, the Americans have the First Amendment. That's enshrined, right? Like that they go to literal war for that. But for us, in our Constitution, and that was implemented in the Charter, correct? The right to free speech. But I've often heard, like, we don't technically have the God-given right to free speech because of what you just mentioned. And what is that exactly?
So, this applies to all of our rights under the Charter of Rights and Freedoms. We don't have anything that's absolutely guaranteed. In court, we call it the Oakes test, because there was a case, R versus Oakes, which was the first challenge to the second Section 2 of the Charter, or sorry, Section 1. I'm misquoting. It's Section 1 of the Charter, and the only way they could get the Charter of Rights and Freedoms through when they were trying to bring our Constitution back in 1982 was to put in this clause that said if the government can prove that taking away the right was reasonable, then the right could be taken away.
Oh, shit.
Yeah. So, we'll use freedom of speech. If the government can prove that it was reasonable to deny you your freedom of speech, then it stands. You lose it.
And that's with all
charter rights? That's all our charter rights. Yes.
That's insane.
Mm-hmm.
Okay, so that explains the use of I keep on calling it the war. Like, let's be honest, the War Measures Act, but they cleverly renamed it to the Emergencies Act, right? Mm-hmm. So that they could use it for things that aren't war. So is that why it's so easy to just declare martial law and then they say, oh no, it's just an emergency, it's not martial law,
right?
Is that why it's so easy to do that?
Yeah. So when it was challenged in court, the court said, well, the government was reasonable for implementing it.
Man.
Or not. So remember, when they challenged that in the federal court, Justice Mosley came out and said, no, it was not justified. Their commission said it was justified. But the federal court, now that's being appealed by the government, another waste of tax dollars. But we had a federal court justice who, ironically enough, was retiring very soon after he made that judgment. But he came out and said, "Nope, you were not justified." But that's what the government's defense was: is that it was justified and reasonable to bring in the Emergencies Act based on what was happening at the time.
Okay, so this charter is not worth the paper it's written on. If there's the backdoor clause, so there's the notwithstanding clause, and now there's basically, if the government deems this to be justified, then you don't really have rights. Well, then you just have like a quasi dictatorial framework that you can just apply whenever you see fit. Yeah, I'm not happy with the way you're criticizing the government. Dave, your podcast is shut down. You can't do that. Yeah, well, we're doing it.
It's reasonable because you were spreading conspiracy theories.
Because you're a useful idiot. You're a useful idiot for Putin. Basically, because that's what the CBS has called me. So I mean, it would make sense.
Me too, apparently.
You too, of course. How dare you criticize the government and our dear leaders? So you can't do that.
Yeah,
that's so insane. Yeah, is it literally? I've got the charter open here, but there's a lot of words on it.
Read section 1.
The guarantee of rights and freedoms.
Yeah. So
the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out. It is subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society.
Yeah.
Oh, shoot.
Mm-hmm.
Okay. Yeah, that's, man. Yeah, when you actually read it in that context, those words really mean something. Subject
yes, they do.
to such reasonable limits. It's not absolute. It's because it says, it's funny. It's like at the very top, it's like, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law, which is basically how the American Constitution is set up. It's like God, the superior being, like these are absolute rights being bestowed upon you that is above and beyond any government that will ever exist. So therefore, if the government is out of line, it is the supreme being that has granted you these, not me as a politician, not the Congress, not the House of Commons. It is literally God. So therefore, you serve your supreme being and the rights that are passed down to you. And this has taken tens of thousands of years of human societal evolution to get to the point where it's like, you have unalienable rights.
Right. But not in Canada.
But not in Canada. Oh my.
Not in the UK, not in Australia.
So none of the Commonwealth, countries
we're all based on the UK system.
Oh wow. Okay, so that's really still
keep in mind why there's a US Constitution. Because they threw the British out,
right?
And they wanted to make sure that somebody couldn't come back in and bring the king back.
Right, which is like my favorite Simpsons episode. Like, do you want the king to come back in here? It's like Mo, he's like poking people in the chest. Like, do you want to come here and stomp all over you? It's funny, but like it's essentially the main reason why that exists, because they wanted to determine their own destiny. And that was a massive shift in just the way humans govern themselves. That's why I'm starting to realize more and more, like, that's the reason why, like, there's nobody coming to save the United States. They are the experiment in freedom that we often look at with, I don't know, arrogance, like, the Americans, look at their system. They can't even, like, their Second Amendment, they allow them. Yeah. The reason why they have those things is because they fundamentally believe that their freedoms are unalienable. Like, it comes from God. So do not mess with them. So that's the gangster stuff that they wrote into it.
Yeah. Their military swears an oath to uphold the Constitution.
Yeah, exactly.
Not to uphold the chain of command, to uphold the Constitution.
It's so gangster.
So, yeah, it's a completely different world.
Yeah, especially when push comes to shove. I was just on a conversation. I just had a conversation with another American podcast last week, and his first question was like, "Hey, how are things going up in Canada politically?" I'm like, "Man, I don't know, man. Like, I honestly, like, I'm just kind of wrapping my head around, like, our system." I was like, I don't think it's good, dude. He's like, "Yeah, explain that." I'm like, "Well, to the best of my knowledge, like, our charter's not really worth anything because you can't enforce it, and nobody will die for it. And even there's a province that hasn't even signed on. Like, I mean, it's like a nothing document because COVID ruined it."
So our conservative government here in Alberta said that they would reform our Bill of Rights here.
So the Provincial Bill of Rights.
Provincial Bill of Rights. Guess what clause they put in there?
Oh, they put the same one. Like, we can just determine that it's not really a thing.
Yeah.
What are Canadians so scared of? What are Canadian politicians so scared of? That we'll actually be in charge, like the people? Is that it?
Pretty much, in my opinion. But yeah, I got to be honest with you, Dave. Until I went to law school, I had no idea.
Yeah.
I thought we have a Charter of Rights. I have a right to religion. I have a right to my speech. I have a right to life and liberty. You know, I have a right to move within my country. I have a right to come and go from my country. My country has to let me leave. My country has to let me come back in.
Wow. But no.
Nope.
That one sentence.
That one little section right at the top. And our Supreme Court has upheld it time and time and time again.
Wow. That's so wild. This is, honestly, Catherine, this is like the best conversation I've had in 5 years, because this is just making me realize there's some serious foundational issues here, and they all stem from, essentially, like, it seems like it just stems from that one sentence. Because if you can't have the underpinning of a right being just foundational, that it is my right regardless of who's in power, regardless of anybody's opinion, then you don't really have rights. You just have, they're what's the best way you can describe it? They're good to have when you're talking about a free and democratic society, but when push comes to shove, they're not really there.
Let's talk about the criminal element of the law. In the U.S., you have what are called Miranda rights.
Yeah,
you're entitled to remain silent. You're entitled to have an attorney present, etc. Canada, you're not entitled to have a lawyer with you when you're being questioned.
Oh, really?
You have a right to speak to a lawyer, and quite often that's a quick phone call from a number that's by the payphone for whatever lawyer you can reach at 3 a.m. to give you some advice and basically tell you, keep your mouth shut, don't say anything. My criminal law professor, when I learned this in criminal law, I was stunned. He said he lost track of the number of times he was sitting outside the room while they were questioning his client inside. So there's not a thing he could do about it.
The police can say, "We don't want you here," to a lawyer.
Yeah, you're not allowed.
It's not your right to have one present.
You have a right to talk to one, but not the right to have one present.
Oh shit! I didn't know that either.
Mm-hmm.
So if I'm really like they're like, so, Dave, you're a useful idiot. Yeah. We're the RCMP's hauling your ass in. I'm like, Catherine, you got to come, like, help. And I'm like, I need her in. They could just flat out say, no, you're not coming. No, absolutely not.
Yeah, you
stay outside. Like, you're not going to be here during our interrogation.
Right.
Oh.
So everything you see in the movies about having a lawyer there that says to the police, no, you're not. No, we're not going there.
Oh no,
that's not in Canada.
I
That's
think
a U.S. thing.
I think I just heard every American just yell into their screen right now.
Yeah.
They're getting ready. They're going to invade. They're like, our Canadian brothers and sisters, we got to come liberate you guys. We need to get a taste of freedom. Holy shit.
Yeah.
Oh, that's wild. I'm learning this right now. Oh, that's not good. Now you got me worried. I'm doing a lot of criticizing.
Yeah. This is why so many Canadian lawyers that do criminal defense work in all their podcasts, everything, that's why they're saying to people, don't say anything. Just,
shut your mouth.
Yeah. When I talk to military members, if they're being called in for questioning, because they can't refuse to attend if they're asked to come in, I tell them, don't even go in a room, just your name, your rank, your service number, and then ask them, am I being detained? And if they say no, wish them a nice day, turn around and walk out. If they say yes, then all your rights come into effect. Don't say another word except I want to talk to a lawyer.
Wow, that's what we're told when we're captured by the enemy. Name, rank, service number. Shut your mouth until you can hold off the pain and the torture so that your buddies can get back to the patrol base.
It all applies in the criminal law system in Canada.
Oh my God. Okay, well, that's some actionable information that I wasn't expecting, but it looks, well, I mean, for a lot of us, I mean, I know even myself, I'm not all that worried that some, like, the long handle of law can come reach out and touch me yet, but definitely during the COVID era, like, I know I was being surveilled. I saw the guy with his camera. We went up and approached him, and then he took off. Like, clearly there was an effort. So why would they do that if they weren't going to try and build a case for whatever reason in the future? So I do have my spidey sense up about it. And if I criticize a little bit too much, I have a genuine concern that the long arm of the law could come out and, like, shut down a podcast, put me in jail, create a whole host of articles that just slander me, because it's happened to my friends. It's literally happened to my friends.
The Online Harms Act, our conversation we've had today, you and I could both be in jail.
Yeah, I know. It's insane.
Mm-hmm. It's insane. Which one of us is going to change gender so we can share a cell together and cause chaos?
Oh man, my wife deals with that with the inmates or the parolees that she had to deal with. Like, they understand how to play the system, right? Like, that's
you may want to be female because the female prisons are nicer.
Yeah, no kidding. Oh wow.
But, I joke, but I have to admit that the Online Harms Bill terrifies me.
It does, because it's the slow walk to totalitarianism, and then people don't even realize, because it doesn't affect them. It's going to be retroactive. Right? Mm-hmm. Yeah.
Yeah. And the other part of it is if they think you're thinking about doing or saying something.
Crime. Thought crime.
Yeah.
Yeah. I'll be the first to say,
and Section 1 of the Charter protects their legislation.
Right. And I've openly voiced that, like, I'm so concerned that I'm considering going elsewhere, because it's not a place that I really want to see deteriorate. Like, I love Canada. I'm a proud Canadian, but I also don't have the means or the organizational, like, power to fight back effectively, because I see what the government is able to do for people that committed mischief. I would never be able to defend myself in that, and that would just ruin me and my family financially, and it's petrifying, and the government knows that. The government knows that, so they can wield that at any point, and that's it. So it terrifies me. So part of my solution is to have a back door that isn't here in Canada, and it breaks my heart to even say that out loud, but it's just the reality of where we're living right now. So I'm really hoping that in the next few years the tide changes. So I'm an eternal optimist, but man, is it, like, we're not in a good place right now. So Catherine, what's the next steps moving forward? Where do you see good things going, and like, what's the best case scenario, I guess, for
this claim? There's a few options we've got, all of which involve perhaps getting it into the court again in a different way. There's a potential my clients may decide to appeal and see where that takes us. Some of the other mandate cases have been allowed to come into the Federal Court of Appeal and appeal. That puts us in front of a panel of 3 justices to decide, not just one. The other part of it is that I think you're going to start to hear a lot more from my clients, social media wise, etc., to get some of this information out there and show people what actually happened. Ones that were a little bit cautious, didn't necessarily want to be too public, are, as I said, you make Canadian troops angry and push them into a corner, they're coming out swinging. Yeah,
That's
definitely, I can see that coming.
Yeah, that's that was going to be my my next plan of attack. Like the battle's lost, but the war still rages. In terms of the individuals that are in this, like mentioned in the statement of claim, right? 330. The individuals that committed some of the most egregious offenses. Like I'm thinking about the, I believe it was a captain that was, you guys were on Andy Stump's podcast together, the Valcartier troop. Like, are those individuals, are they named in the statement of claim? And
yes.
Like, so those individuals, like, I'm just curious, like, is there any way that those individuals can individually be held accountable in a court of law outside of this claim, or now is like the shot's been fired across the bow, so therefore they no longer have any legal liability?
Part of the problem is time. We have a statute of limitations. It's 2 years.
Yeah.
That's the biggest barrier we've got. Otherwise, there could be 458 individual claims brought.
Yeah. Okay.
But part of what we're looking at because the abuse continues, abuse of power continues. It didn't go anywhere. We do have people that have had things happen to them in the last 2 years that potentially could be bringing their own cases.
Okay.
Yes.
Well, one example, when we're talking about hitting the social media networks with a renewed vigor. If we look at the Americans and their social media influencers, there's quite a few that their channel is based upon highlighting abuse of power, and they call out individuals by rank, by name, and their laws protect them from libel, essentially, to a certain extent. Now, for the listeners, if they're going to do anything like that, what does Canadian law allow in terms of mentioning somebody on a social media post for an alleged offense?
So if you're going to be accused of defamation of character, the defense for a defamation of character is that it's the truth. So if you're going to name and shame, make sure you've got all the backup. Do you have emails? Do you have witness statements? That's your defense.
Okay.
Because a defamation case, it's up to the person who's saying they've been defamed to prove that they've been defamed. So it's up to them. And your defense is it's the truth. And if it's the truth, they haven't been defamed because you're telling the truth. This is where reporters in like the National Post or on CBC or CTV, this is why they don't get sued if they're reporting factual. Truth.
Right. Exactly. Things that they've
Such
seen.
As it is sometimes when I see.
But sometimes they can get it wrong, but ultimately they're doing their or supposed to do their due diligence to ensure that there is a level of investigation that warrants the claims. And I've seen this in my friend's case. They made up stuff. That's really troubling. But podcasters are clearly there, and the podcast space has now entered into the next phase where a podcaster like Joe Rogan is the kingmaker for the presidential race. Podcasters have a bigger reach than mainstream media now. So the podcaster, in my opinion, is going to have a lot more responsibility on their shoulders to actually bring forth things that are very factual, and they do their own research because they are essentially a citizen journalist now. And so these cases, and I'm speaking to the individual listening right now, dot all your I's, cross all your T's. And if you're going to go out and you're going to go hard, make sure you have the corroborating facts.
Yeah.
And I think we can all play that game now.
It'll still save you lots of money on your lawyer won't have to charge you so much to defend you if you've got all the
Doesn't mean you won't get sued.
Well, it doesn't mean you won't get sued.
Right.
But if you've got the receipts. And quite often someone brings a defamation claim, you're served, your lawyer then sends their lawyer, well, here's the evidence, here's the facts. And their lawyer will say to them, don't pursue this.
Back off.
And most people will listen to their lawyer. Some people don't. They will continue. But that's where things fall apart behind the scenes.
Gotcha. Well, Catherine, thanks again. This has been a very informative conversation as per usual. And I'm really curious to see where this all goes and how this affects the Canadian, I guess, experience for not only those in the forces, but just Canadians in general. And I hope more people take this, share this, listen to it, think critically about what's going on here, because, our country just doesn't run off of Tim Hortons and hockey. There is an underpinning of democracy and what that means in order for all of this to function. And these are the topics that we need to actually dig into. And especially those that are serving in the forces, they need to know that the country has their backs, and that on the back end or on the front end, we go above and beyond to make sure that your sacrifices are actually honored. And if it's in the justice system, then so be it. So, Catherine, thanks so much again for coming onto the podcast and chatting about the updates with your lawsuits. And I'm sure you'll be on sooner rather than later regarding some other issues that surround the CAF. So any last thoughts before we sign off today?
No, I just want to say to everyone that people need to become more politically active in Canada, because what the courts have basically said to us is that they're not going to change the law on their own. We need the Parliament to start changing the law, start changing how things work. And so Canadians need to stop being asleep and look to our neighbors to the south, get organized, get talking to people who are running for office. We're going into an election sooner or later here. Mm-hmm. Are you talking to your political candidates? Are you saying, this is important to me? Because if they hear it from you, there was a saying way back that one letter to a politician was 1,000 opinions. That was years ago. So be vocal. Let them know. This is what's important to me. Mm. And whether it's military related or otherwise, doesn't matter. We need to start making our opinions known and make it known that you're not going to get elected if you're not going to listen.
That's a great point.
Because that's how we change things.
It's a great point. So I'm going to take that one to heart. And folks, I hope you do too. And Catherine, where can folks find more about Valor Legal?
So we are quite active on X. It's at Valor Legal. VALOUR, legal, Canadian spelling. Yes. We are also, our website is valorlegalactioncenter.org.
Perfect.
Because it's a nonprofit that runs the bigger lawsuits. So.
Perfect. Well, Catherine, thanks again. And yes, I definitely echo your sentiment on getting in touch with your leaders, making sure they know. Because if they don't know, they have no visibility. And I just chatted with some last week. They have no idea what's going on in veteran land. So if veteran topics and issues are important to you, make sure your political leaders know. And thanks again for tuning in, folks. Don't forget to train hard, fight easy. See you on the next one. Peace.